Greetings and welcome to Summary Judgment, Part 10, What May Be Considered. And one thing to consider is that this is strictly for the entertainment and educational purposes of this YouTube channel and broadcast, not to be used, misconstrued, or abused.
Hippie 1776 says hit the like button, people.
Indeed, yes, and thank you, and cheers to you for the membership. Yes, nothing in this broadcast is to be used, misconstrued, or abused for anything personal, private, legal, lawful, business, tax, financial, or otherwise, so please don't do this at home. That said, let's get started. And yes, we do have the talking chat enabled, so if you simply just type in,
The tribe says hit the like.
You'll be featured with both the voice and with your actual comment.
Craig Curry G5E says always.
Indeed. Well, greetings and welcome to you all. I'm glad notifications went out. That said, let's get right down to it. So, where we left off last time is under generally here still. So, under federal rules, this is the federal rules of civil procedure, and similar state rules, various materials may be considered in determining whether there is no genuine issue as to any material fact. We went over both what makes a genuine issue, what makes a material fact, and whether the moving party is entitled to judgment as a matter of law. So Federal Rule 56C expressly includes answers to interrogatories among materials that may be considered on summary judgment motions. That's along with admissions, affidavits, depositions, things like that. Facts deemed admitted due to a party's failure to respond to requests for admissions are sufficient to support summary judgment. So facts deemed admitted due to a party's failure to respond to requests for admissions. So your failure to respond to a request for admissions can be deemed admitted fact. So even if you decide you don't want to speak, it will be deemed admitted that whatever facts were there that you didn't speak to. Trial courts may properly consider judicial notice, stipulations, or depositions from former actions involving the same subject matter and parties. So similar parties, similar subject matter, former action, you could have those judicially noticed. Certified transcripts of prior judicial proceedings may be considered when made part of the record. So, of course, judicial notice, make it part of the record, then it would take that judicial cognizance to have it considered. That would be through motions or other means there. Transcripts possess same indicia of reliability as affidavits in summary judgment context, indicating matters to which witnesses would testify. So these are just like an affidavit. It has to be a matter which witnesses would testify. So those transcripts possess the same indicia of reliability as an affidavit.
Grammar 1 says, I just got pulled over and didn't sign the ticket for promise to appear on the court date. It's for no proof of insurance. If I didn't contract with their corporation, I don't have to show up, right?
Jesus. Well, I don't know. Salute to you, Officer Murphy. Indeed. Yeah, that's a pretty sticky situation. And of course, the contract isn't necessarily something that they are going to need to present. The contract is presumed. It's whether you can rebut that presumption that that contract exists. And again, as we're seeing here with rules of summary judgment, is there a dispute of facts? If so, is one side entitled to a judgment as a matter of law if there's no dispute of facts? Otherwise, it sounds like something where the facts need to be decided by a jury unless, as we just read here, facts deemed admitted, okay, that their contract may exist due to a party's failure to respond for requests for admissions are sufficient to support summary judgment. So ignoring it, in effect, very well could deem those presumptions as admitted facts. So I couldn't tell you what to do in that situation, but I think what we're seeing here in the lesson is that there are some to be considered there. But let's proceed. Certified transcripts of prior judicial proceedings may be considered when made part of the record. So, same situation before? I don't know. Transcripts possess the same indicia of reliability as affidavits. So, those transcripts, certified of course, would have the same reliability or indicia of reliability as affidavits in the summary judgment context. All right.
Craig Curry G5E says, wish they told me about this presumed stuff in school.
Well, that was the whole point of not telling you and keeping you where you're not finding out about it.
Ramerfee1 says, okay, I'll just comply with my corporate slavery that I was born into without consent.
Well, just make sure that's your clear response. Getting hemmed up in their system is never a fun thing, indeed. But just like anything else, you get caught up with a pack of wolves circling you. It's not a good situation either, but nevertheless, you have to deal with it. Okay, so as we're seeing here, that the transcripts, affidavits, in the summary judgment context, both indicating matters to which witnesses would testify, those would possess that same indicia of reliability. All right, so we're on to some cases here. And as we spoke before, that in the summary judgment cases, these move pretty quickly because there's no trial, no jury, no deliberations, strictly on whether the facts are disputable and whether parties entitled to summary judgment as a matter of law. So, improperly submitted supplemental materials. Here, the plaintiff failed to provide a legal brief explaining why facts cited.
Craig Curry G5E says, I demand better government daycare.
Yeah, well, again, it's be careful what you ask for. Nevertheless, so a plaintiff failed to provide a legal brief explaining why facts cited in supplemental statements were relevant or couldn't have been submitted in the opposing statement as required by local rule, so court would not consider such materials in summary judgment proceedings. So this is an interesting one here, improperly submitted supplemental materials. So again, the local rules really apply because the summary judgment is kind of a drastic measure here. It's getting around the whole fact-finding part of a jury and that whole aspect of a controversy. Therefore, local rules are there to kind of hem in the chaos that could ensue from something of such a drastic remedy. And that comes from Liston versus Corporate Officer Severance Plan, and that's in Maine, 2002. Now we have internet citations as background information. Court determined that internet citations are appropriate for background information in a summary judgment motion, recognizing their utility for establishing factual context. That's from 2001. That's a long time ago. So, again, this is a 2008 supplement we're reading from. I'm sure there's much more current cases, but you could kind of see the direction these things have been going. And that was from California, 2001. Now, the expert testimony on industry standards. District Court excluded expert testimony on underwriting practices from lending executive not designated as expert on commercial mortgage-backed securities industry. Who's a big one here. Oh yeah, this is the LaSalle. All right, so let's check this one out. The District Court excluded the expert testimony on underwriting practices from a lending executive not designated as expert on commercial mortgage-backed securities industry. While better practice would have been to explain the decision, the court could conclude testimony was irrelevant to CMBS industry standards. So he wasn't the right expert, seems like. That's LaSalle Bank National Association versus Nomura Asset Capital Corporation, 2005, Second Circuit. Now we're on to the specificity requirements in summary judgment. Plaintiffs numerous citations to voluminous Exhibit 1 and full affidavits when resisting summary judgment motion did not meet specificity requirements of the summary judgment rule. So the voluminous Exhibit 1 and full affidavits. So numerous citations to this, right? It did not meet the specificity requirements of the summary judgment rule. That's Tolan versus Ashcroft. It's 8th Circuit, 2004. All right. And before we move on, just to see if everyone here in the chat, just to do a little interaction here, please hit the like if you have not already, just to get the notifications out, because if you stick around to the end, we have a very special surprise at the end to make this all worth it. So let's continue on. The evidence admissibility at summary judgment stage. Remember, the evidence isn't supposed to be weighed at this stage. So let's see what admissible evidence there is at summary judgment stage. Parties need not submit evidence in the form admissible at trial. However, the content or substance of the evidence must be admissible. Okay, so the actual evidence doesn't need to be admissible at trial, but the content or substance must be of the admissible type, so nothing privileged or those kinds of things. Let's see here. That's Bryant versus Farmers Insurance Exchange, 10th Circuit, 2005. Now, information and belief in interrogatory answers. Information and belief, so first-hand knowledge. For purposes of summary judgment proceeding, district court will not consider as evidence portions of plaintiff's answers to interrogatories which are identified as being based on information or belief rather than personal knowledge. And that's from Portis versus Dillard Storage Services and Alabama Middle District, 2001. Now we're on to the former employee testimony relevance. A former restaurant manager's deposition and declarations would be stricken from the record at summary judgment stage of Patron's Section 1981 action alleging race discrimination, where a manager had ended employment several years earlier, and his testimony was devoid of allegations of customer race discrimination at restaurant in question. Oh, that's Jackson versus Waffle House in Georgia, 2006. All right, let's keep moving along here with the county director's inconsistent statements. Court would not consider statement in terminated county housing director's summary judgment affidavit. What did he say in this affidavit here? The county commissioner insisted on favoring family and friends, where director's deposition testimony did not specify these allegations and failed to mention state senator. Gosh, that's Mack versus Augusta Richmond County, and that's again in Georgia. So the court wouldn't consider statement in terminated county housing director summary judgment affidavit that the county commissioner insisted on favoring family and friends. So this guy was terminated. The court would not consider the statement in his affidavit where his deposition testimony did not specify these allegations. Okay, he says he just favors family and friends, but there's no specificity. Again, that specificity is necessary. You can't just say it seems like or it's a conjecture. There has to be more than a mere scintilla of evidence. All right, legal memoranda as evidence. Legal memoranda and oral argument are not evidence and do not create issues of fact on a motion for summary judgment. And that's Nowick versus Gamel, and that's Hawaii, 2004. Interesting one there. All right, now we're on to the unauthenticated corporate charter. Ooh, wow, this is from Kansas in 2003 and subsequent determination 2004. Grogan versus O'Neill. All right, court would not consider unauthenticated copy of corporate charter in support of motion to dismiss claim that exculpatory provision barred assertion of corporate waste claim. Charter copy was document outside pleadings, not to be considered in dismissal context, and court would not convert motion to summary judgment. Wow. All right, so better have that corporate charter authenticated. And then the affirmative defense requirements. A defendant relying solely upon affirmative defense to thwart plaintiff's summary judgment motion must establish both applicability of the defenses and triable issues of fact. Both the applicability, such in the law, and the triable issues of fact as to existence of each essential element. Plaintiff needs only to establish inapplicability of identified defenses or that essential component is missing. That's from Conoco versus J.M. Huber Corporation, Kansas, 2001. Now we have email as summary judgment evidence. Emails are proper summary judgment materials as long as they are properly authenticated or shown to be self-authenticating. That's interesting there. That's from Uncle Henry versus Plot Consulting, and that's Maine 2003. Moving along here. And as you see here, we have a lot of cases when we go through this within the summary judgment context, because this is pretty much where all the real rubber meets the road, so to speak. There's only so many rules, and you see a lot of repetition, dispute of facts, matter of law, but it goes beyond that into all this specific scenarios. And because there's no trial, no jury, none of that, these cases actually go by rather quickly. So it gives us a chance to sharpen our saws, so to speak, and to really get the skills of analyzing cases and seeing how they apply to the subject matter and the topics of each section. All right, now we're on to speculation versus personal knowledge. A club owner's speculations as to the meaning of city council members' silence regarding ordinance prohibiting sexual contact did not constitute facts within the owner's personal knowledge, and thus could not be included in owner's affidavit opposing city's motion for summary judgment. Silence regarding the that sounds pretty creepy there, and that's Ways versus City of Lincoln in Nebraska 2002. Failure to respond to material facts. Facts asserted by defendant in statement of material facts annexed to summary judgment motion, to which plaintiff completely failed to respond or responded only by asserting facts were not relevant, would be deemed admitted. So again, that specificity and completely failed to respond or responded only by asserting facts that were not relevant. So again, there has to be connection, there has to be specificity involving responses and motions for summary judgment. And that was from Gallimore Wright versus Long Island Company here, New York, 2005. Newspaper articles as hearsay. Newspaper articles and transcript of city council hearing contain statements of out-of-court speakers, which were neither under oath nor making admissions against their interests, and thus were inadmissible hearsay in summary judgment proceeding. So, yeah, and city council hearing. Wow. That's Friedman versus City of New York, 2002. Now we're on to the credibility of evidence in summary judgment. A court may not consider credibility or weigh evidence in deciding motion for summary judgment, even if quantity of moving parties' evidence far outweighs that of its opponent. So it's not about the quantity, you don't get to weigh it, period. And that's Super Fresh Food Markets versus United Food and Commercial Workers Local Union, 2003 in Pennsylvania. Now we're on to the medical expert testimony on survival chances. Oh man, hope that medical expert isn't Kevorkian. The medical expert's opinion that heart attack victim would have had a 34%
Breakery G5E says media hearsay is all propaganda anyway.
Indeed, it should be common knowledge of that, but again, see who was trying to get away with that anyways. That was Fridman versus City of New York. Yeah, only in New York they're going to try that one. Yeah, I heard it in the news, so we're going to try and bring it into court. All right, so we're on to the credibility of evidence. So the court may not consider the credibility or weight of evidence. Then we had the medical expert on testimony of survival chances. Again, hopefully this is more of a Dr. Oz than a Dr. Kevorkian. But let's see here, the medical expert's opinion that heart attack victim would have had 34, not 33 or 35, but a 34% chance of survival had city ambulance been appropriately dispatched, was scientifically reliable and admissible for summary judgment motion, where expert was licensed physician with 50 years experience in cardiology. That's a good one. 34%. And he must be good. Beeswick versus City of Philadelphia, 2001, Pennsylvania. That's a good medical expert there. He can nail that. Not 32, not 41, 34% chance had the city ambulance been, and he knows what an appropriate dispatch too. That makes it scientifically reliable and admissible. But remember, this is only for summary judgment motion. That wouldn't make it a trial. I don't believe.
Breakery G5E says he should have taken his 11th booster.
Yeah. Well, this is 2001, so that's a world away. All right, let's move along here to reference to non-record materials. The defendant's reference in statement of material facts to transcript that was not part of the record violated the local rule requiring specific reference to record and thus precluded grant of summary judgment. Wow, it has to be in the record. That's Vasquez Garcia versus TransUnion de Puerto Rico, 2002. All right, moving along. That should take us to the burden of proof on summary judgment movement. So the one making the motion for summary judgment. If movement for summary judgment has burden of proof at trial, movement must support motion with credible evidence using materials specified in rules of procedure. Here they are: pleadings, depositions, answers to interrogatories, admissions, and affidavits. So those are the materials specified to be used to support credible evidence that would be used for summary judgment. If the movement says that these are undisputed facts supported with credible evidence using the materials specified. So that's from Vercott versus General Motors, Alabama, 2001. Then we have written objections to evidence. In summary judgment proceedings, defendant did not waive written objections to evidence by not repeating them orally at hearing. Wow, okay. Statute required objections to be made at the hearing, but not necessarily orally. So interesting there. Read your statutes. The statute required objections to be made at the hearing, but not necessarily orally. Wow, now that's from Tilley versus CZ Masters Associations, and that's California, 2005. Now, resolving facts and inferences in favor of non-movement. So, on motion for summary judgment, trial court is required to resolve all facts and inferences which may be reasonably drawn from evidence in favor of party against whom ruling is sought. So resolve all facts and inferences. So again, these pleadings, depositions, answers to interrogatories, admissions, and affidavits, if there's any question about whether they're, admissible or applicable. It's required to resolve all of that in favor of the non-movement. So you just don't want to get carried away there. Want to state as stuff that even if it's being looked at in favor of the non-movement, it would still draw towards granting a summary judgment. So that's from Underhill versus Thompson, Kansas for 2007. And securities fraud expert testimony. Yeah, Bernie Madoff's brother. Experts' affidavits, which took shareholder statements as true without reviewing the record to verify support, could not be considered on summary judgment motion regarding the shareholders' securities fraud claim. That's in Ray Acceptance Insurance Company's Securities Litigation, 8th Circuit, 2005. Then the expert discovery deadline compliance and legal malpractice action. Court properly refused to consider client's expert submissions in ruling on attorney's summary judgment motion, where court had ordered discovery to conclude by specified date, extended that date several times, and client failed to identify experts within the time without a reasonable explanation. There's no excusable neglect there. And that's from Batsy's versus Rothschild, 2005, Second Circuit. And the student loan debt evidence, certificates of indebtedness, qualified as competent summary judgment evidence supporting government's motion on student loan debt, despite borrower's contention they were conclusory hearsay statements. Okay, so this is not specific. Loan analyst supplemental affidavit regarding Department of Education's record-keeping practices cured any deficiencies. Well, that's U.S. versus Lawrence, and that was 2001, 5th Circuit. All right, and that takes us to Section 50. Requirements that evidence be admissible and hearsay. What we say about hearsay in the summary judgment. Well, only evidence or statements that would be admissible on trial. Doesn't mean they have to be proved at the summary judgment stage, but they have to be admissible on trial and have probative force, may be considered in ruling on a summary judgment motion for summary judgment with specific rules regarding hearsay evidence. So we have specific rules for the hearsay evidence. Evidence excluded at trial may not be used as basis for granting summary judgment in favor of party offering it. So it can't be excluded at trial if it's being used in a summary judgment. Inadmissible evidence may be considered in ascertaining whether a triable issue exists, thus may be basis for denying summary judgment. Ascertaining whether the triable issue exists. Exhibits without proper foundation to authenticate them cannot support a summary judgment motion. So again, you need that authentication, as we saw there, like from the company charter, etc. Then the district courts have broad discretion to rule upon admissibility of evidence in summary judgment proceedings. So discretion. District courts have broad discretion to rule on admissibility of the evidence, but only in the summary judgment proceedings. But you see here a lot of discretion given to the court. Each document submitted in support of summary judgment must be properly authenticated or self-authenticating under federal rules of evidence. What's self-authenticating? Things like certified copies from clerk, etc. Where there's someone that could stand and say, yes, this is true and correct, or it can be traced back to someone with authority and responsibility for that record. All right. Anecdotal evidence in trademark case. The district court appropriately considered only admissible evidence in ruling on summary judgment. Although anecdotal evidence is admissible to establish actual consumer confusion, court has broad discretion to rule on admissibility of those anecdotes. So, again, they have discretion. We know where that goes, and that's Nora Beverages versus Perrier, Group of America, Second Circuit, 2001. Improper expert testimony in employment discrimination. The district court properly excluded the plaintiff's expert witness and his summary judgment affidavit in an employment discrimination case. The affidavit offered improper opinions concerning compliance with NASD regulations, contained hearsay assertions, and offered irrelevant conclusions. So, improper opinions, hearsay assertions, and irrelevant conclusions in his affidavit. It sounds like a weak affidavit. Of course, that gets excluded. That's Grabovac versus Allstate, 8th Circuit, 2005. Hearsay in prisoner speech therapy affidavit. Now that seems prisoner's speech therapy affidavit, but hearsay. Okay. References in inmate's summary judgment affidavit to questions allegedly asked or statements made by state representative constituted inadmissible hearsay and had to be stricken, though inmate could recount his own statements. In fact, that representative visited him. He could recount his own statements. In fact, that the representative visited him, but he can't make references. To questions allegedly asked or statements made by the representative. So he can't say that he asked me this or that. He could say that he could recount his statements or the fact that the representative visited him, but he cannot put the statements that were asked or made to him by that state representative in the affidavit. So they give you a little bit of a way of refining these things. That's Miller versus Correction Corporation of America. Jeez. Miller versus this Corrections Corporation of America, and that's Alaska, 2005. Oof. Now we have the unauthenticated documents as evidence. Documents which have not had a proper foundation laid to authenticate them cannot support or defend against a motion for summary judgment. That's Birch versus Regents University of California, 2006. Then we go to affidavits from unavailable witnesses. Oh boy, the unavailable witness. You get his affidavit, we just can't find the guy that wrote it. Without affiance, availability to testify and undergo cross-examination, due to death or dementia, then the court could not credit affidavits as anything more than inadmissible hearsay on summary judgment motion and products liability action. So if they're dead or crazy, then you can't use their affidavit because they can't stand there to be cross-examined on it. It's nothing more than inadmissible hearsay at that point. Woof. That's Bortel versus Eli Lilly in DC 2005. Now we have the attorney's affidavit, not based on personal knowledge. Yeah, and this Eli Lilly one here, yeah, I guess death or dementia from the Eli Lilly stuff, huh? All right. Attorney's affidavit, not based on personal knowledge. Summary judgment affidavit of plaintiff's attorney was not made on personal knowledge, and thus inadmissible in admiralty suit, where affidavit included argument, citations to record, and summaries of record evidence. So there it is. It was not made on personal knowledge. That's Danabrog, Radiri. That's from the vessel True Dream in Southern District of Florida, 2005. All right, come on. Now, the legal memoranda, not considered evidence. Legal memoranda in oral argument are not evidence and do not create issues of fact for purposes of summary judgment motion. So remember this, the legal memoranda and oral argument are not evidence and do not create issues of fact. So the legal memoranda and the oral arguments do not create issues of fact for purposes of summary judgment motion. Doe versus Kamahama schools. That's Hawaii, 2003. Disregarding inadmissible evidence. District court could simply disregard and thus would not strike portions of summary judgment exhibit that were not admissible under federal evidentiary rules. So they're not even going to acknowledge it. That's Baxter versus Briarcliff College Group Insurance Plan in Iowa, 2006. All right. Y'all still with me? We're almost done here, and then we're going to get to the best part. Authentication requirements for documents. Each document submitted in support of summary judgment must either be properly authenticated or must be self-authenticating under the federal rules of evidence. And that's Gorgwin XREL Estate of Gogwin versus Textron in Massachusetts, 2006. Some of these names are worse than Latin. All right, now we have a security seller's statement. It is not hearsay. Oh, a court would not strike a statement in summary judgment affidavit that president of seller told marketing representative there were prospective investors who did not meet requirements. Statement was based on personal knowledge and not hearsay as it recounted statement of a party opponent. Oh boy, that's Pinnacle Communications International versus American Family Mortgage, Minnesota, 2006. So this is interesting here. That the president of seller told the marketing representative there were prospective investors who did not meet requirements. This statement was based on personal knowledge. Statement, summary judgment affidavit. Whose affidavit? Oh, well. All right. Expert evidence admissibility determination. The court may determine the admissibility of expert evidence for purposes of a summary judgment motion. So, again, that's to the discretion of the court for the admissibility of expert evidence. Those expert witnesses, they must have a good gig going there, and he had to stay on the judge's favor. That's MCI Constructors versus Hazen and Sawyer, and that's North Carolina, 2005. Now we get to the city officials' statements as hearsay. Alleged statements by current or former city officials offered to show adverse zoning decision resulted from protected First Amendment activity were hearsay and not competent summary judgment evidence, as they did not fall within hearsay exclusion for admissions by party opponent. So the alleged statements by the former city officials showing their adverse zoning decision, that's hearsay. And that's Dickinson Leisure Industries versus City of Dickinson in Texas, 2004. All right, now we're on to the record. Section 51. If you're still here, please indeed hit the like, and we do have the talking chat enabled, so if you're so inclined to pipe up in the chat, we'll read it and display.
The tribe says, hit the like.
Just like that. All right, let's move along. The facts alleged in pleadings are not the sole factors to be considered in passing on a motion for summary judgment. So not just the facts alleged in the pleadings, all those shown of record as it stands when the motion is made or submitted enter into the matter. So there you go. Get those judicial notices in before that motion or with the motion, right? Courts look to pleadings, depositions, answers to interrogatories, admissions, and affidavits to determine existence or non-existence of material facts. What are material facts? Facts that can affect the outcome of the case, not supporting facts. Court is neither required nor permitted to independently search the record to find support for facts offered by a party. They may, but they're not required. Oh, nor permitted to independently search the record to find. So, okay, they can do certain things sua sponte, but they're not going to find support for facts offered by a party. Under Rule 56C, court is obligated to consider only materials specifically offered in support of the motion, but also all pleadings, depositions, answers to interrogatories, and admissions properly on file on the record. So you can't refer to something that's not on the record. In collecting record for summary judgment, federal district court must sift out non-English materials, English only, and parties should submit only English language materials. You get that? All right. Non-movement need not cite specific page numbers of record, but must present designated portions with enough specificity that court can readily identify facts upon which they rely. So point by point, paragraph by paragraph, page by page, but you got to pick something with specificity that the court can readily identify. All right, now let's check out some cases involving the record. First of all, we're going to start with Gonzalez de Blasini versus Family Department, and that's First Circuit 2004, the English language requirement for record. Press 1 for English. In collecting record for summary judgment, federal district court in Puerto Rico must sift out non-English materials, and parties should submit only English language materials. All right, let's move along. Specificity requirements for non-movement. Although summary judgment non-movement need not cite specific page numbers of record in support of claims or defenses, designated portions of the record must be presented with enough specificity that the district court can readily identify facts upon which the non-movement relies. And that's from Cloak versus West Claremont, Local School District Board of Education, 2006, Ohio. Then the court's authority to grant summary judgment. Here we go. This is a big one. In deciding a summary judgment motion, the court may search the record and grant summary judgment to any other party entitled to judgment, even if that party has not moved for that relief. See, now here's a strange one here. In deciding a summary judgment motion, the court may search the record and grant summary. So it's not them finding support for facts. This is in deciding the summary judgment. The court may search the record and grant summary judgment to any other party entitled to judgment.
Even if G5 says, I wonder where the world would be if all Germans spoke English since 1900.
I wonder where. Of course, we do have some elements of German law that have made it into our common law, such as the demurrer, which is not Latin. It's actually Germanic in its origin. But I digress. Let's get back to the program here, the English-only program. So the court's authority, they can decide it based on the record. They can search the record and grant the summary judgment to any other party entitled. So they've got a wide authority on that, and that's Keonis, Calabera, whatever. That's New York 2005. Oops. Where is it? Oh, Lord. All right. Is that where we are already, huh? Excellent. Yeah, so this one moves a little bit quicker. We're on to section 52. Allegations in the pleadings. The court is not limited to allegations of the complaint when determining a defendant's motion for summary judgment. So the defendant's motion is not limited to allegations in the original complaint. But certain pleading allegations may be eliminated from consideration depending on the procedural context. Okay, so let's see how we split this here. Allegations specifically denied by the answer must be eliminated from consideration in determining plaintiff's motion for summary judgment if plaintiff proceeds without evidence after filing answer. So the allegations specifically denied by the answer must be eliminated from consideration in determining the plaintiff's motion if the plaintiff proceeds without evidence after filing the answer. So the defendant here, I guess, or the one...
Craig Curry G5E says one of the requirements of my profession is that you can read and speak English.
As are many, at least here in the United States of America. All right, so we have the allegations that are specifically denied. So again, that specificity is being knocked out here. If that's the case, then if the plaintiff proceeds, they need to have further evidence, it seems. Then the stricken allegations and pleadings may not be considered in disposing of summary judgment motion. So, of course, stricken allegations are out of it. Sworn pleadings constitute evidence for purposes of summary judgment rules. So our affidavits and such, sworn pleadings, verified complaints, perhaps. We'll get into that in a moment. And the non-filing of responsive pleading, the non-filing, does not automatically entitle opposing party to summary judgment on basis that allegations are admitted as true, because it still needs to be ruled as a matter of law. And timely filed motion to dismiss may excuse requirement to file responsive pleading until court rules on pending dismissal motion. All right, so let's see how this all pans out here. Here we have the procedural due process violation as motion to amend. Police officer's argument in opposition to municipality's summary judgment motion that lengthy delay in providing his post-termination hearing violated due process was constructive motion to amend complaint. Since complaint did not allege he requested hearing or facts relating to period after termination. Lengthy delay. This is Hill versus City of Scranton, 2005. Then we get the non-filing of responsive pleading. The employer's non-filing of responsive pleading to complaint did not entitle the union to summary judgment on the basis the employer had accepted allegations as true. Because remember, the non-filing means that they may be regarded as true, the allegations. Employer timely filed motion to dismiss and was not required to file responsive pleading until the court ruled on the pending dismissal motion. And that's Milk Drivers, Dairy and Ice Cream Employees, Local Union versus Roberts Dairy, 2003 in Iowa. That's the milkman, huh? Don't see those much anymore. All right, it takes us to the oral testimony, Section 53. The admissibility of oral testimony in summary judgment proceedings varies by jurisdiction, with some courts permitting it at their discretion, while others consider it to convert the proceedings to a bench trial. So the oral testimony varies by jurisdiction. So under Federal Rules of Civil Procedure 56 and similar state rules, oral testimony is admissible at court's discretion in summary judgment hearing. Some jurisdictions hold that oral testimony is not admissible in summary judgment hearing, as hearing oral testimony converts proceedings to a bench trial. Ooh, look at that. So test your jurisdiction and see whether oral testimony is admissible at the court's discretion. In some jurisdictions, courts are statutorily permitted to hear oral testimony at summary judgment hearing, but only in rare circumstances and for exclusive purposes of clarification or correction. Deposition testimony, like affidavits, in support or opposition to summary judgment motion, must set forth facts as would be admissible in evidence. Then the unsigned discovery responses without supplemental authentication are inadmissible as evidence for purposes of summary judgment motion. Alrighty. So we're getting now down to the nitty-gritty with the oral testimony. And come on, there we go. Hearsay testimony regarding tax numbers. Testimony that Quebec tax officials had learned that Georgia golf cart manufacturer used false tax numbers and was unauthorized to collect Quebec provincial sales tax QST was properly excluded in summary judgment as out-of-court statements offered to prove truth of matter asserted. Testimony was inadmissible hearsay, and that's from Club Car Incorporated versus Club Car Quebec Imports, and that was 2004. It looks like certiorari was denied. All right, deposition testimony requirements. Deposition testimony, just like affidavits, in support or opposition to a summary judgment motion, must set forth facts as would be admissible in evidence. So that's facts, and not just any facts, but ones that would be admissible as evidence in the case. Watson versus Adecco Employment Services, Florida, 2003. Now the unsigned discovery responses. Unsigned discovery responses without supplemental authentication. So remember, the authenticated documents are inadmissible as evidence for purposes of a motion for summary judgment. And that's Nelson versus City of Flint, Michigan Eastern District, 2001. All right, let's move along here. The deposition testimony requirements is very good, just like affidavits in the deposition. We must set forth facts admissible as evidence. That's a good one to remember. Let's move along. And now we're on to section 54, evidence excludable under a dead man's statute. A dead man's statute provides that as to transactions with a person now deceased, the surviving party is made incompetent to the extent that his or her testimony might be questioned by the deceased person if he or she were still living. So, evidence is excludable under a dead man statute, but may be considered in opposition to a summary judgment. Won't make it a trial, but could be used in opposition. So, evidence excludable under a dead man statute cannot be considered to defeat a motion for summary judgment unless defendant has waived rights under the statute. If offered to support a motion for summary judgment, evidence excludable under a dead man statute cannot be used. So if it's offered to support a motion for summary judgment, opposition is okay, but if it's offered to support the motion, the evidence is excludable under the dead man statute, so it can't be used. But it may is a key word, discretion, may be considered in opposition. The waiver of a dead man statute rights allows certain evidence of plaintiff to be considered to defeat summary judgment. So if someone's waiving that dead man statute's rights, the dead man statutes may vary by district and jurisdiction, but generally aim to prevent parties from testifying about transactions with deceased persons. Yeah, you can't say I sold it to Joe and yeah, he's dead, so we can't testify. All right. Now it takes us to section, we're already there, right? Yes, no cases for section 54, the dead man statute, pretty clear there. Now we're on to the affidavit that contradicts an earlier deposition. We saw here about clarifying, but what about contradicting? This takes it to another level here. And I hope you all are still staying here with me because coming up very soon is a very special surprise at the end of this one. So stay tuned for the best part. All right. The admissibility of affidavits that contradict earlier deposition testimony and summary judgment proceedings varies, with courts examining whether contradictions are adequately explained. So this is key. The courts will examine whether the contradictions are adequately explained. A person may not create a material issue of fact to defeat summary judgment by filing an affidavit disputing his own sworn testimony without plausible explanation. So you can't create your own issue of fact dispute. All right. Summary judgment affidavit may not be excluded solely on ground that it conflicts with prior deposition. It may create issue of fact under some
Grade per
circumstances.
EG5, says. Is the surprise Dave Chappell?
Dave Chappell. Yeah, it's Dave Chappell. That's a good one here. You get Chappelle coming out of here, but maybe you need to use a proper code there for the C. All right. But it may be. You need to stay tuned. It may. It's just up to discretion. The discretion of this channel. Okay. Let's see here. So the affidavit that amplifies or explains deposition testimony may create issue of fact precluding summary judgment. We saw before. You can add in if there's some confusion previously, then affidavit may create additional issues of fact that would preclude summary judgment. And a court must consider an affidavit submitted in opposition to Rule 56 motion, even though it conflicts with earlier deposition testimony. So it has to be considered. Court may only grant summary judgment upon finding that affidavit presents a sham factual issue. So if there's a sham factual issue, then it doesn't affect the summary judgment, so it gets granted. And we saw what the sham issues were from the previous presentation. Let's move along here. All right, we get to a practice guide here for section 55. These practice guides are gold here. In determining whether the contradiction between a deposition testimony and subsequent affidavit is adequately explained, court should examine 1. Whether the deposition afforded opportunity for direct and cross-examination. So, was there an opportunity to cross-examine the one being deposed? 2. Whether the witness had access to pertinent evidence prior to or at the time of deposition. So, were they have firsthand knowledge of what they're speaking to, in other words. And or whether the affidavit was based upon newly discovered evidence. So were they aware of what the affidavit's clarifying, or is it on newly discovered evidence? And 3, whether the deposition testimony reflects confusion, lack of recollection, or other legitimate lack of clarity that the affidavit justifiably attempts to explain. So that's whether, this is your test here, whether the contradiction between the deposition and the subsequent affidavit is adequately explained. Those 3 things. So if any of those things here is a good reason to, I guess, consider that affidavit or to clarify earlier confusion with the new facts presented in that affidavit. Then we get on to the case here for inconsistent statement explanation. Here's how it works. For purposes of ruling on police officer's motion for summary judgment in arrestee's Section 1983 action alleging excessive force, the arrestee's deposition testimony should not have been disregarded because it was inconsistent with sworn statement to internal affairs officer. Arrestee offered an explanation for prior inconsistent statement, creating issue for fact finder. So there it is.
Grade per EG5, says. Would you say the system is about truth or about who is in charge?
I guess depends which system here. ultimately, it's about who's in charge, of course, but if the person in charge or whoever is in charge is focused on the truth and finding facts and the rule of law, then that's the key. Now, who's in charge? Is it the judge? Is it the person bringing forth the complaint? The one defending against the complaint? The bailiff? So I guess it gets into a deeper dynamic to consider. But I digress. Let's continue on this one here. These inconsistent statements. This officer here in Cobb County, Georgia in 2005. So the arrestee's deposition should not have been disregarded because it was inconsistent with a sworn statement to an internal affairs officer. So the arrestee offered an explanation for the prior inconsistent statement. So yeah, that makes sense. Let's continue on here. Then we have the conclusive versus factual testimony. Arrestee's sworn deposition testimony that he was disarmed and handcuffed when officers struck him with fists, baton, and pistol grip, and ordered police dog to bite his leg. Boy, after hearing the guy that got beat up and then shot in the head, this one gets struck with fists, baton, pistol grip, and a police dog biting his leg. This was not conclusory, and thus raised a dispute of fact that was genuine on United States motion for summary judgment on FTCA assault and battery claim. That's Arlington versus U.S., D.C. Circuit 2006. Wow, so that the arrestee's sworn deposition that he was disarmed and handcuffed when all this happened was not conclusory and thus raised a dispute. Okay, oh, good. All right, corporate officer's declaration. The district court properly denied motion to strike the declaration of a corporate officer despite alleged contradiction between the declaration and deposition testimony, where deposition statement simply reflected officer's opinion and declaration statement regarding nature of stock purchases agreement was not actually contradictory. That's Russ Incorporated versus Bay Industries in Southern District of New York, 2003. And now we get to the affidavit clarifying. Been waiting for this one, the one that clarifies the deposition testimony. An affidavit may be considered on a motion for summary judgment if it clarifies rather than contradicts a deposition. So clarifying, not contradicting. So Livingston versus South Dakota State Medical Holding Company, that was 2006, of course, South Dakota. Then resolving conflicts between testimony. On summary judgment, conflicts between deposition testimony and subsequent affidavits or declarations are resolved in favor of deposition testimony unless the conflict is explained. So again, the clarify, not contradict. Explain is the only way that affidavit can resolve previous conflicts or other conflicts from the previous testimony or depositions. Now we have conflicting inferences from the same party. So let's see here. As a general rule, if conflicting inferences may be drawn from a deposition and from an affidavit filed by the same party in opposition to a motion for summary judgment, a fact issue is presented. Oh, wow. An appellate court does not disregard the affidavit as a sham. Wow. So look at this. Conflicting inferences from a deposition and from an affidavit from the same party in opposition now. This is in opposition to a motion. That's from Del Mar College versus Vela, Corpus Christi, Texas, 2007. The motion was granted. All right. And that was a, all right. And this previous one was Calendars versus Quiet Flex Manufacturing in Texas as well, 2006. All right. Hope some of you are still there. Boy, I know this has been a long one, but we got a lot through this. It takes us to our favorite part now, the special surprise to test your knowledge with the summary judgment quiz. So here's how this works. In the chat, you put in the question number and then your choice for that question. So if on question 1 I was going to choose D, I would put in the chat 1D. Okay, I'm going to read the questions. I'm going to read the answers to give you guys time to answer them. Answer them in any sequence you want, but I'm just going to go through and start reading them now. So for question 1, under Federal Rule 56C, which of the following materials may be considered in determining a motion for summary judgment? So which of these can be considered? A, only pleadings and affidavits. B, pleadings, depositions, answers to interrogatories, admissions, and affidavits. C, remember, materials to be considered. Only evidence that would be admissible at trial. Or D, only expert testimony and certified documents. Okay, do we have any takers in the chat? Going one more time here for question 1. Which materials may be considered in determining the motion for summary judgment? Pleadings and affidavits is A. Pleadings, depositions, answers to interrogatories, admissions, and affidavits for B. C is only evidence that would be admissible at trial. And D, only expert testimony and certified documents. Any takers on this? Come on.
Craig Curry G5E says, I need the guy form last night to help me out. Craig Curry G5E says 1C.
All right, we'll take 1C. Remember, there's all about just having fun and testing your knowledge here. Again, I know not everyone could have been paying attention this whole time. It's been a pretty long presentation, but hopefully you caught it because there is a lot of repetition, or I should say restatement of these principles here throughout American jurisprudence to see a multifaceted way of getting these concepts through, and hopefully some memory aids so that you can remember them. And here's one place where you can test them. So here's question 2. What is the general rule regarding hearsay evidence in summary judgment proceedings? Remember the general rule regarding hearsay. A, hearsay evidence is always admissible in summary judgment proceedings. B, hearsay evidence may be considered to deny summary judgment but not grant it. C, hearsay evidence is never admissible in summary judgment proceedings. And D, hearsay evidence may be considered only if properly authenticated. Authenticated hearsay. I like that. All right. So any takers for question 2? Again, is it hearsay? What general rule regards hearsay in summary judgment? Is just for summary judgment now. Is it always admissible in summary judgment proceedings? Is it may be considered to deny summary judgment, but not?
Craig Curry G5E says 50% is good, but we learn from the answer description.
yeah, it's I guess you could say that. But again, some of these here are pretty straightforward. This is an easy one to guess at because this is take a guess at question 2 anyways. And, when you think about it, hearsay is typically not going to be admitted into a trial. And we only had one situation where hearsay would be considered in a summary judgment proceeding. So I'll give you that hint there. Go ahead for question 2. Any takers on question 2? We're moving along to question 3. What is a general rule regarding affidavits that contradict earlier depositions in summary judgment proceedings? So we just went over this. What's the general rule regarding the affidavits that contradict earlier depositions? A, affidavits that contradict depositions are always excluded. B, affidavits may create issues of fact if they explain or clarify deposition testimony. They may create the issues of facts if they explain or clarify. C, deposition testimony always outweighs contradictory affidavits. Or D, only affidavits with new evidence can contradict depositions? This is pretty easy here. Come on, some takers for question 3. Is it A, affidavits that contradict depositions are always excluded? B, affidavits may create issues of fact if they explain or clarify deposition testimony? C, deposition testimony always outweighs contradictory affidavits? Or D, only affidavits with new evidence can contradict depositions? All right. No one's going to pipe up. We'll go on to question 4. When may evidence excludable under a dead man statute be considered in summary judgment proceedings? Come on, someone's going to guess at this one at least. The dead man statute. When may evidence excludable under dead man statute be considered? Right? So never. This is always inadmissible. B, only to support a motion for summary judgment. C, only to oppose a motion for summary judgment. Or D, both to support and oppose a motion for summary judgment. So this is evidence that's normally excludable under a dead man statute. He can't come and testify as it being true, but one could be considered for summary judgment, even though it's excludable under that dead man statute. Is it never? Is it only to support the motion for summary judgment? Is it only to oppose a motion for summary judgment? Or can it be considered to both support and oppose summary judgment motions? The dead man's statute exclusion. Anyone taking a guess on this? This is an easy one. Think about it. All right.
Paper EG5E says, hold on, just put on TV so I can read it.
Oh, okay. So yeah, I'll leave this on the screen here, and I'm going to read through again question 3 because nobody took an answer to question 3. We can edit this part out, the double reading of previously on the edit the video later, but for now I'm going to do it. So question 3, what is the general rule regarding affidavits that contradict earlier depositions in the summary judgment proceedings? Is it A, the general rule regarding the affidavits that contradict the depositions earlier? A, the affidavits that contradict depositions are always excluded. B, affidavits may create issues of fact if they explain or clarify the deposition testimony. C, deposition testimony always outweighs contradictory affidavits. Or D, only affidavits with new evidence can contradict depositions. So there it is, and I'll leave that there, and we're going to read question 4 again. Now again with question 3, pretty straight here, the rule with affidavits that contradict depositions. So there's an earlier deposition, the affidavit contradicts.
Paper EG5E says 3B.
All right, we got a 3B. So yes, let's have high confidence in that. But question 4 again is, when may evidence that's normally excludable under the dead man's statute be considered in summary judgment proceedings? So this is something that you normally can't use at a trial, and unless everyone waives it, but excludable under the dead man statute, but considered in summary judgment. When may this be done? Never, as it's always inadmissible. B, only to support a motion for summary judgment, so on the movement. C, only to oppose a motion for summary judgment, meaning the non-movement could use it. Or D, both to support and oppose summary judgment motions. Question 4, dead man statute exclusion consideration for summary judgment. So going once, going twice for question 4. All right, we're going to move on to the answer key.
Paper EG5E says my guess is 4D.
All right, good guess. But now we're going to get on to the funnest part of all. the answers. All right, here we go. Okay, so for question 1, under Federal Rules 56C, which of the following materials may be considered in determining a motion for summary judgment? And the answer was B. Pleadings, depositions, answers to interrogatories, admissions, and affidavit. Those are the materials that are considered. Federal Rule 56 expressly includes answers to interrogatories among the materials which may be considered on a motion for summary judgment. All right, so B was the answer for number 1. Excuse me. So, question 2. What is the general rule regarding hearsay evidence in summary judgment proceedings? And the answer was B. Answer was B. Hearsay evidence may be considered to deny summary judgment, but not to grant it. And the explanation is that evidence that might be excluded at trial may not be used to grant summary judgment, but may be considered in ascertaining whether that triable issue exists. So it might be there just to see if it needs to go to trial, but it definitely can't be used as evidence to rule on the case. On to question 3. What is the general rule regarding affidavits that contradict earlier depositions in summary judgment proceedings? And of course the answer was B. That's an easy one here because affidavits may create issues of fact if they explain or clarify the deposition testimony, because a summary judgment affidavit may not be excluded solely on the ground that it conflicts with the prior deposition if it amplifies.
Gregory G. says, I missed all 4 and totally shit the bed.
No, you got one of them right here, didn't you? I think you got one of them right here. Okay, I thought you had 2B, but nevertheless, 3B is they create issues of fact if they explain or clarify deposition testimony. So the key here is that if they amplifies or explains or clarifies the deposition, it can introduce new facts or create issues of facts with that affidavit, even though it seems contradictory because you explain why that contradiction brings up an issue of fact. Okay, so we're on to question 4. When may evidence excludable under a dead man statute be considered in summary judgment proceedings? And C is only to oppose. Remember, it can't be used to grant the motion, but it can be used to oppose it, because if it's opposed, it means it goes to trial. So it's still not going to be a ruling on the case. Evidence excludable under a dead man statute may be considered in opposition to a motion for summary judgment, but not to support such a motion. All right, there were no wrong answers. It's a matter of we need Bill out here. Yeah, indeed. I know why. He must not get notification tonight. The notifications seem to have been pretty thin on this one. Nevertheless, salute to you all for being here. The thing is that by participating in the quiz, testing your knowledge, seeing the answers and the explanations, hopefully it'll solidify some of the things we talked about here and give you some memory aids to be able to use this should it ever become necessary. Hopefully not. Hopefully the preparation being the best form of prevention. That said, I'd like to thank you all for attending tonight, and I hope to see you all on the next one. Peace out.
Craig Curry G5E says quit sucking up tribe. I try harder next time.
Hey, it's all about our participation. We only get better by doing. No sucking up there. But again, this isn't supposed to be easy. What do you think law school is all about? All right. Thank you all for being here. We'll see you next time.